Hello, everyone. Welcome to the Green Effect podcast. This is episode number 31, which is part 2 of 2 with Lisa Nadon, Paralegal with Small Matters. Before we get into that, just a reminder that the show is sponsored by Ignite Volleyball. If you're looking for a great volleyball club for your son or daughter, make sure you visit the website, see what there is to offer, ignitevolleyball.ca. On to Lisa. So, in part 2, we talk about how to handle tenants who are not paying their rent. We talk about notices, using the notices, managing your investment properties like your business and like you're a business owner. We talk a little bit about the eviction process. How does it happen? What does it look like? What are the timelines? How do you make sure that, as she puts it, you don't have a fatal issue where you got to start it all over again? The tribunal. Is it as much fun as it sounds? I use an example. Is it like people's court? She's going to talk about what the tribunal is all about. Finally, we end with the top 5 list of mistakes landlords make. Again, everything in this episode is note-taking worthy. If you're a real estate investor, got to make sure you listen to this episode and take notes. Here we go with Lisa.
Welcome to the Green Effect Podcast. Finance, life, business, and everything in between. And now, your host, Stephen Green.
Tenants not paying. And you know, what percentage is we talk about all the doom and gloom with owning rental properties, right? And your tenants not paying and big parties and windows broken and people jumping off, whatever. So if things are done right and you follow your gut and you do your due diligence, this doesn't happen terribly often where tenants are not paying. 2% of the time, 5%. I mean, what how often does this happen?
See, and I don't know statistically. If you ask me that question, I'm in the Landlord and Tenant Board 4 days a week. So I probably scare off a lot of people by saying, in my view, it happens a lot. But yeah. I know that I'm in the board probably for 10% or less of tenants, the true tenants who are out there who enjoy their place, take care of their place, pay their rent on time, those kinds of things. So it's hard. I try not to get jaded and not to assume that the entire world doesn't want to pay for a roof over their head. So it's one of those things where...
Wrong person to ask is what you're saying.
Well, but I do know that it is a small percentage. Yeah. I mean, real estate is a great investment. I have lots of friends that are in it, and lots who are knowledgeable. And the fires don't start. If you know what you're doing, read up on the information either through the website, educate yourself. You're going to stop a lot of those fires, and you're going to have tenants who are going to appreciate you, know that you're educated, and keep the lines of communication open, and you're going to get probably respected information back from your tenants, and you're going to have an open, honest relationship.
And maybe not being taken advantage of.
That's right.
Is that maybe a good way to put it? Right?
Yep.
We're going to talk about that in a sec too. So on that note, tenants not paying. So now you got your tenants not paying the rent.
Right. So tenants not paying the rent. This is the first thing I would tell any landlord. There are hundreds of reasons why a tenant is not paying you the rent. This is your business. It's your investment. It's your business. Their reasons can be sad, can be heartbreaking, can be horrific, can be silly, crazy. There are a million reasons why someone can't pay the rent or won't pay the rent. You need to get those notices out. Rent is due on the 1st of the month. You have to get them out on the 2nd of the month. It allows you 14 days. It allows the tenant 14 days to pay. So you can be sympathetic and you can say, look, we understand the situation. This is our business. We have to start with giving you this form. It still allows you 14 days to address the rent arrears, but we need to move on it.
That is, if there's any new landlords, that advice is priceless, because I've seen it. And as we know, I do mortgages, so I've seen tenants not paying rent for months and months. And the key thing you said there, this is your business, and you do have 14 days. But Mr. and Mrs. Tenant, here's your N. What is it? N2, N4.
N4.
Here's your N4 on day 2. Don't take it personal, but you still have that time. But I have to start the process because I got to pay my mortgage, right? The bank's not going to say, oh, we understand the problem, don't worry about it. It's So what you just said, I hope all new landlords, and existing for that matter, take that to heart. So
please read those notices carefully. If you mess up on that notice, even a small clerical error, it could be fatal. And if you file the application and it gets to the board and your notice is not accurate, you have to start all over again.
So what's inaccurate? You mentioned earlier spelling of names.
Spelling of names is one. Okay. Termination date being off by a day.
Okay. Yeah.
Is a big one.
Okay.
Rental period. Rent is due on the 1st of the month. So October rent is due October 1st.
Sunday, so Thanksgiving doesn't matter. I know it's not Thanksgiving, but it doesn't matter. Okay.
Doesn't matter. That rental period is the 1st of October to the 31st of October. Even though you're giving it on the 2nd of October, that rental period when you're filling out the calculation is the full month.
So there's no such thing as a business day?
No.
Okay. That's important to know.
Yeah.
Because I've heard that from tenants. Oh, it was a Sunday. Oh, the bank's not open.
Doesn't matter.
Right.
First is the first.
Thank you. Okay, good. Yep.
Yeah. And so that's a big one. I see tons of notices come back, and the rental period is the biggest one. They will put the 1st of October to the 2nd of October, rent is $1,700. Right there, it's fatal. It doesn't matter whether the tenant comes to that hearing. It doesn't matter if all the amounts are accurate. It's a fatal notice. Doesn't matter. You have to start again.
Yikes.
So it's imperative. Notices cannot be corrected or amended. Applications can be.
Okay. And so, you know what? As frustrating as that might be, though, I think you want to make sure, as the board, you want to make sure that at least the tenant is being treated properly. So they're not going to take, shoddy paperwork. Frustrating, but I get it, right? Yep. That makes sense.
Well, I mean, the example I gave, the 1st of October to the 2nd of October at $1,700, basically you're saying the rent is $1,700 a day.
Yep.
So that's inaccurate.
Yeah.
And again, we talk about the landlord and tenant board. Look, they have all the instructions right there. The notice itself tells you exactly how to fill it out, tells you what the timelines are, how to address it. Read the instruction book right beside the notice. Read the 2-page notice, which really is a paragraph of information, but that's going to tell you how to fill out the form.
I can tell you already, as someone who was the kid in the back of his primary school class who never did his homework properly, I would be bad at this. I'll tell you that right now. So it sounds like if you're not good at paperwork, get someone to help you with it, because it might be a long process.
Yeah, for sure.
And that's something you do, right?
It is.
Okay.
Yeah. And it is. And at the end of the day, sometimes our fees will seem like a lot, but the landlord and tenant board right now, even if you did it on the 2nd of the month, we're booking dates at least 2 months out right now.
Yikers. Yeah.
So you're going to be...
Time is money, right?
Well, sure, 2 months out. Yeah. You're 3 months out already.
Wow.
Then they give more time to pay. Then these things happen. What I'm saying right now, and this is just due to backlog and shortage of adjudicators and staff, you could be anywhere between 4 to 6 months before you get that tenant out, or at least repaying that debt. 4 to 6 months in rent arrears. That's a lot for a small landlord who has other bills to pay. It's a lot for any landlord.
And if you get to 3 months for your hearing and then your paperwork's wrong,
yes,
you got to start this whole thing.
Yes.
Yeah, okay, that's not good.
So
That's not good.
it needs to be done quickly, efficiently, and correctly. I mean, a lot of times, if you're going to hire someone like myself, I'm going to give you a copy of that paperwork. You're going to see exactly. So now you have an example.
Yeah.
So maybe you only pay for me or another professional once. See how it's done correctly, then go ahead and try it on your own.
Or they like not doing it at all, and like, yeah, you can do them all now.
Well,
for
maybe.
me. Thinking like a business owner. Okay, so your N4 goes in day 2. They don't pay by day 14. Day 15, I'm assuming, so I have
Yep.
14 days to pay. Then what?
Yep. So on the 15th day, you can apply to the board. You can do it online, which is great. That's only happened in the past few years. So you upload your notice, you upload your certificate of service, you fill in the application, you get a hearing date booked right online right away.
Okay.
Not a date to attend right away, but you know the date that you will be attending.
Yeah.
And then the board sends out those notices of hearing and that package to the tenant.
So what if your tenant pays within the next couple of months? Do you still go through the process, or do you cancel it, or
Yeah.
do you say, okay, no hard feelings, no big deal?
So a notice allows 14 days. If that notice runs into a new rental month, they would have to pay the rent that's noted on that notice plus any new rent that comes due. If
Okay.
you file the application because they haven't paid or they only gave you a little bit and haven't paid the full notice amount, then you apply to the board. Once you apply to the board, if you do it online, the application fee is $175. That is automatically owed by the tenant. So not only would they owe the rental arrears that you're asking for, they owe that application fee as well.
Oh, interesting. Okay.
If they pay all of that before the hearing date, then yes, you just email the landlord and tenant board and say we're withdrawing the application as the tenant's paid.
And they got to pay the application fee, the rent. They got to pay it all.
Yep.
And then they're clear and they're
That's
good to
right.
go.
Yep.
And then if it happens again, there's the whole thing starts all over again.
Starts again, yep.
Again, if you're putting your business hat on and it is your business, you got to pay the mortgage. It makes sense. Probably more time consuming. $175, whatever it is, that's the cost of doing business. And it sounds like if they're for real is not a right term, but if they legitimately had something and they're ready to pay, get your money back, withdraw, and then off you go, right? I mean, it sounds like life happens, right? Sometimes you got to run your business, but if they make good on it, they make good on it, right? So,
Yep. Yep.
you know.
So any non-payment of rent applications are what you would get out of the board on that hearing. So let's say they don't pay you anything, you go to a hearing, tenants don't show up, and now you've got to add 2 or 3 more months rent onto that. So do know that just because your notice was for October, let's say your hearing date isn't until December, all of that rent gets added to the application you already filed. So you don't
Alright.
need to do any new notices. You will be allowed to ask for October, November, December rent at the hearing. An order will come in the mail if the tenants don't show saying you owe X amount of dollars, you need to pay this within 11 days, and if you do, you can stay. Okay? L1 applications are called pay and stay orders. So it's not what's called a non-voidable termination. I have had clients where they're like, I just want them out. I don't want to take their money anymore. You can't refuse payment of rent.
Because I'm sure a lot of people get to that point,
do.
right? Yeah.
Because you're upset. I'm just going to evict you anyways. I don't want your money. Just get out.
Yeah.
You can't refuse rent. And know that the only order you will ever get out of the board on that is the ability for the tenants to make good and keep their home.
But if it's gotten that far, generally speaking, do you see a lot of people coming to the table with a few $1,000s to
All
back
the
up
time.
their rent? Really?
All the time.
Does it just have to get that far for them to realize this is for real? Like, why do we have to go through all that? And I don't know, that's a tough question to ask you, I understand, but why? What would possess someone to have to push it this far? And now you pay all the rent.
I think circumstances are different. I think in general, I see a lot of the time and again, I've been doing this for so long, so you kind of see all kinds of things. And then I did small claims before that, mainly with regards to credit card debt. So people like, I don't know if they like to, if they ignore it, they think it might go away. Or if they don't say anything because they don't know how to say anything, that I can't afford to pay you right now, and they don't know how to just say, look, I'm come on hard times. I don't really know how to deal with this. Yeah. Then there's lots of reasons why. So a lot of people, I don't think their intent is to, well, most tenants, even the ones, and even though I do go in the board a lot, most tenants are not in it to get away with not paying. Yeah. The circumstances vary.
Interesting. It's funny, they ignore it and hopefully it goes away. That's what I do with my wife sometimes at our house. So it goes across all lines.
So I think you just need to keep an open mind and understand that people's circumstances change. You don't know what their personal life is happening right now, and you don't know why. You just know that I need to pay the mortgage and I'm not getting paid, and I don't know why you're not paying me, but it must be because you just don't want to, which isn't the case most of the time.
Well, same with my question, right? Why are we even here, right? Mm-hmm. Why do we even get to this point? And,
yeah.
But like what you said, it's you don't know.
You don't know.
And you're right, they're not going to come out and open up, for the most part, I think, to the landlords, and this is all my problems I'm having. But then as a landlord, you got to have that balance of, okay, thanks for all that, but now pay your rent, right? Yep. It's a tough one.
But then being educated, if a tenant did come to you after you filed an application or a notice, you can, again, still be sympathetic and say, I can work with you. Just because these notices and applications have termination dates on them does not mean that's the only option when we get to the board. Yeah. We can work out repayment plans that allow you to stay. We can address those types of things, but we need to have it in a proper form or agreement that if things go off the rails, the landlord's not stuck at square one again. The landlord has some kind of security to enforce that.
To start the process if need be. Yeah.
Well, to complete the process would have been started. True. So one common one is a payment plan. Tenant comes to this L1 hearing. Look, I've had a lot of trouble, just lost my job, have 4 kids I need to feed, and husband left, sort of thing. I can pay $200 extra plus rent on the first going forward. We can work out a payment plan like that. Yeah. But if they fail to make any one of those payments, even if those payment plan goes into the next year, any one of those payment plans, if they default on that, we get an order in the mail terminating their tenancy. So now you're already halfway or 3/4 of the way through the process, but you're still working with your tenant.
Which makes sense. Really, mm-hmm. I mean, that makes sense, right? What percentage ends up as eviction? Like, you get that far, how often does that actually happen? Like people showing up and saying, get out. Like the marshal? Sheriff?
Sheriff.
Okay. Sheriff, like how often does it get to that point?
Well, we file orders quite frequently with the sheriff. Okay. I don't know percentage with respect to how many actually get forced out. A lot of times, once that order comes, the tenants are going to leave before you're even enforcing the order on the sheriff.
They don't want to be dealing with that, right?
They don't want to. It's an extra fee that we can put back onto the tenants. So in Kitchener, that fee for a sheriff to attend is $325.
And I'm guessing, and that gets thrown on their tab.
If you can, if you know where they work, then you can garnish wages, those kinds of things, and add that fee onto it. But if they don't have a job or assets of some kind,
or life has just gone sideways completely,
then yes, it's a disbursement that gets added to the tenants, depending on whether you can actually get that payment out.
Do landlords actually? So it goes that far. It goes to the tribunal. It goes to eviction. Now you're in the whole 6,000-7,000, whatever, after fees and time and mortgage and whatever. how often do landlords just call it a day, write it off, and rent it out again, or do they actually go the way of garnishing wages, trying to get the money back? Do they actually go that direction?
I work with landlords all the time, reminding them that they can enforce those orders. So whether that be through collection agencies, whether that be if you have the right information through me to enforce it, it's in your best interest to try, or at least find out whether you can. There are times where orders are not, if you don't know where they work, or they're not working right now, or they left the province, or they left the country, then we're going to be able to tell you it's not worth the fees to enforce it. There are many variables, but orders don't get placed on credit bureaus. They don't
Really?
get picked up unless you purposely place them.
Garnishments won't show up?
Garnishments will,
Okay.
but the actual order from the Landlord and Tenant Board does not get picked up by Equifax or TransUnion and placed. So if it
Rogers
went
and Bell is on there, but this is not.
right, it needs to be forced on. So whether that be through terms of enforcement wherein you transfer it into small claims court, or whether you hire a collection agency who places it, or whether you use someone else who can place those orders, then at least will then show up.
Okay. Yeah, because that would be important if they're going to rent another place.
It can be, yep.
Right, then they know that this has gone on. So, okay, so so we won't go through too much of the eviction process. I mean, obviously, if it gets to that point, there is something there. The sheriff goes out, does what he or she needs to do. Anything that you've seen go well with those, or go horribly wrong? Anything that the landlord should know if it's gotten to that point? If they got to go out there and get their like, what about their stuff? Like, do they get to, if their stuff is not gone?
Right.
What do you do with their stuff?
So if a sheriff comes and they're coming to enforce the eviction.
And tenants aren't there, they're gone, long gone.
So if the tenants are long gone, landlord just changes the locks. So ensure you have a locksmith there, or have a way to change the locks. And now you have legal possession of your place back to go and re-rent it, do whatever you need to do to get it back on track. If there are belongings in there, then the tenant has 72 hours from the time the sheriff attends to be in contact with the landlord to retrieve their belongings.
Okay.
After that 72 hours, the landlord can do what they wish with those belongings, although I would always strongly suggest you take pictures, take an inventory. If there's sentimentals or mementos or sentimental items, things like that, if you can try to hold it, or maybe call someone based on the application form they originally gave, there is always a risk when you start just saying, well, the act says 72 hours and I can just throw everything out.
Pull up the Just Junk truck and start dropping it in.
Yeah, and I mean, technically that's what the act says.
Yeah.
That can happen.
Can you sell the stuff? Like garage sale?
You dispose of it as you wish.
Okay.
Yeah.
No,
after
I mean,
72.
I don't know if it goes this extreme, but I mean, that's one way to
Yeah.
recover funds, right? Just
Yeah,
off
I
you
would
go.
just be very cautious in
I think so, too.
how you do that. And again, most of the time the people are gone. The stuff that's left there are going to be garbage.
Yeah.
Really. There really isn't going to be much in the way of anything of value.
Yeah.
Usually. I mean, we've had
There sounds like there's stories there you don't want to say.
Well, yeah. I mean, I've had applications in the board where tenants have left $25,000 in their kitchen drawer. I mean, you can tell by the face of it that might be a little bit exaggerated,
Yep.
but these types of, it just becomes an annoyance because you need to address it. So how do you address it? You make sure you document everything. You make sure, great thing about digital or cameras or cell phones, everything is digital. You don't even need to copy anything anymore.
Yeah,
Just
that's
stick it in a
true.
file just in case.
Yeah. That was so true. So true. Okay, so tribunal. I've never, knock on wood, I've never been there before in any respect. I've got a vision of like the people's court. Like what goes on there? Is it like I don't want to say like a regular court. I'm not trying to minimize it, but it actually, like, is it an actual judge? Is it you said an adjudicator? Okay,
So
tell me about
they're
that.
adjudicators, not judges.
Okay.
They're members of landlord and tenant board. So they are like a judge. So for the average person who doesn't know the court system, they are a judge. The cases are heard. It's more of an informal court setting than if you've ever been to a regular civil court. It's not as formal, but there is still a process. And that adjudicator makes the decisions.
Okay.
Most of those decisions all of the decisions are made as per the act. Most of the decisions can't be really of their opinion. So they can't say, well, I think that you're really trying and you can stay. They have to go by the application before them.
Oh, and,
so
I would assume that for
yes,
sure. Yeah.
so they do have the ability to give a little bit of their opinion or make orders based on scenarios, but it's very limited. Okay.
Makes sense.
They have to rule on what's before them, not. And what I see a lot is, well, we have a rent arrears application, but they damaged the place.
Mm-hmm. Okay.
So I have all my invoices and I want to show you that they've damaged my place and I want to ask for that.
Mm-hmm.
You can't bring up things that are not in the application. So if you didn't file on damages,
yeah,
you can't bring up that stuff on damages. You can't add things in.
That actually makes sense, though.
Right.
That makes sense because they are. Okay, it makes sense probably from someone who's outside looking in. They're two different things,
Yeah.
but I can see a landlord doing that, trying
Right.
to state their case as to what the heck's going on in that house, right?
Right. So they have to go directly by those applications and they have to go by the letter of the law, which is where those, if you mess up on a notice, it's fatal, comes from. So very specific in what they can do. Okay. And they can rule based on what they've heard in limited capacity. So we talk a lot about the rent arrears application. So they can order a payment plan. You may not agree with it, but they've listened to that tenant and said she's lost her job, she's just starting a new one, she can make $200 a month. Mm-hmm. They can order that.
So they're caught up in X number of months. And then, okay.
So they have discretion to do that. They have discretion to deny eviction. Mm-hmm. They have discretion to delay eviction. Tenants have the ability to bring up any issues they want on an L1 application, which is rent arrears.
Interesting. Okay.
So even though the Act says you cannot withhold rent for any other purpose, it will be discussed at a hearing if a tenant wants to raise, I've had no heat, or you didn't put any windows in, those kinds of things. So again, you need to be educated in your property, educated in what is upsetting your tenants, so that you can go to that hearing with the right evidence and information to either dispute that these things are happening or to explain why they happened and what you've done about it.
Is there a burden on the tenant, though, as well, to provide the same proof, not just say the heat was off or there's a window missing? Is it the same burden on them too?
They do need to provide evidence.
They can't just make it up.
They
right?
can't just make it up. Okay. But if both parties just come with nothing but he said, she said testimony,
you leave it in the hands of the adjudicator.
Then you leave it in the hands of the adjudicator. Maybe you're an honest guy, but you come across as a witness not great. You hesitate, you don't really remember what exactly happened, you don't remember dates, and this tenant it was October 2nd and it was at 3 a.m. and you came banging on my door and this woke me up and you called me names and on and on and on. Yeah. Maybe the credibility is going to look more favorable on the tenant because you didn't know, you weren't prepared, you were kind of blindsided. You
were unprepared.
Yeah.
Yeah, it is what it is. So if I don't come across real well, you can go for me, right?
I can't go for you when...
Is there anyone that can go for me?
If they're bringing up allegations, we need to have witnesses there or evidence. So can people other than the landlord go? For sure. If you have a property manager that runs your place,
can go. Okay.
to give the evidence.
Okay.
So if they're acting on your
show
behalf, right, if they're the ones who are the face, the everyday face to your tenants, then of course they're the witness for that particular situation.
Okay.
But then again, if it's just unpaid rent, then yes, you can have a licensee go for you so you don't have to not go to work. But if there's any issues with allegations or maintenance, those kinds of things, then we would need documentation or at the very least someone showing up to.
Okay, so those are two completely different streams then. Okay, that makes sense. So I have to, there's one in KW, right? A tribunal? Like where?
Yeah, it's at the Kitchener Odd now.
Oh, it was Kitchener Odd.
Yeah.
Is it like a show? Like what? Can you buy tickets for this?
Yeah, they have rental rooms there, so that's where they're being housed now.
And how often do they go? Like how often does it run?
Well, I'm usually there 4 days a week.
Okay, so, oh geez, okay. Wowzers.
Yeah, and then Guelph, Brantford, Woodstock, London, Toronto, Mississauga, Hamilton.
And is that busy of a market that it goes 4 days a week like that? And
in Kitchener-Waterloo.
And then you're 2 months out.
Yeah. Well, you think Kitchener-Waterloo because it's Kitchener-Waterloo, Cambridge.
Okay.
Right, so you're...
Student rental stuff increase that?
Probably.
Yeah. I mean, let's just
We don't
assume,
see
right?
as many in student rentals. So, I mean, I deal a lot with student rentals, but a lot of those applications are those aren't what's making it 4 days a week. We do get them from time to time, but again, like I said, we handle those different.
Yeah, so that's a whole other podcast. So.
Yeah.
Yeah. Okay, so top 5 list. What is the top 5 list that new landlords make? Go.
Top 5 list. 2 mistakes. 1, they don't fill out their notices correctly.
All right, that's a good one.
That's one is the biggest one I see. 2, they don't provide the proper information to the tenants, whether it be their full contact information, whether it be how are they going to pay their rent, or how do you want the rent accepted.
Email money transfer is okay?
Email money transfer is okay, but the Act says you cannot specifically tell a tenant how they can pay their rent. You can't force them to pay by post-dated checks. You can't force them to pay by email money transfers. So that one is hard.
You can force them to not pay by cash though, right? I wouldn't want cash. I mean, that's such
it's money.
Really?
Money's money.
That would make me so nervous.
Right.
Like just, I gave you 1,500. Well, there's only 1,000 here.
Yeah.
Right. But
So give receipts right away, specifically if it's cash.
good point. Okay. Yeah.
Okay. If they're supered units or supered buildings, then maybe what we have done in the past is offered other avenues. Let's say there was a bank right across the street from the building. Provide a deposit account number. If you wish to pay by cash, please go to whatever bank across the road, and here's the deposit account number. You can pay for it right there. You get a receipt right there.
Perfect.
Okay,
Yeah.
that's a way. What tenants don't get is it's not the landlord's responsibility to chase the tenant for the rent. So if you have multiple buildings, or even if you don't, it's not your obligation to go knocking on the tenant's door on the first, second, third, and fourth all the time.
Yeah.
It's the tenant's obligation to get you that rent. That being said, if you don't provide them on how to pay that rent, then that becomes problematic.
And that'll become an issue later on if you're trying to evict and stuff like that.
It can be.
Yeah.
So other mistakes, probably the leniency in allowing things to carry on.
Yeah.
The next biggest mistake is this is your investment, which means you need to inspect your property at the very least once per year.
Okay.
The Act is very clear. It is ultimately the landlord's responsibility to maintain their property.
Make sure it's not a grow up and there's parties going on
You cannot expect your tenant to tell you issues that are going on in your investment. It would be lovely if they would tell you, and a lot of tenants probably would.
9 times out of 10, if not more. Yeah.
Right.
Yep.
But there are a lot that will not,
Okay.
for whatever reason.
So you can do stuff like furnace inspection annually.
Yes.
You can inspect something or other, or not. I don't want to say make things up, but something like that would probably just be a good practice anyway, right?
You are allowed to enter with 24 hours written notice to inspect the rental property.
For no reason at all.
You are inspecting the rental property.
Okay.
Now, that being said, you can't go every month for 12 months without it potentially being a harassment issue, of course. Understand this is, yes, it's your property, and this will probably be another mistake that landlords might make. It is your property. You do own it. You chose to be a landlord, which means you chose to provide a home to someone. So this is their home.
Yeah.
Understand that. Yes, you have rights as a landlord, but tenants also have rights to live in their home. How would you feel if you were in that tenant's position? So I always, remind yourself, how would you feel if you were in that tenant's position going to do what you're going to do right now?
Yeah, if the bank said, well, you're mortgaging this property, so you can't quite make this mess, or you can't cook this way, or...
Correct.
I've never thought of it that way, but that's absolutely correct. Yeah.
Yeah.
Yeah, and that's tough. So understanding that you have taken on that risk, it is a risk, it is what it is.
Yep.
But thinking of it from that perspective, that's a very, very good way to put it. Yeah.
Yep. So along with that, yes, it's your home, it's your investment, so you need to take care of it. But you also need to at least have some confidence that your tenants are going to take care of it as well.
Yeah.
But definitely inspect every year.
Yeah, and I had one client where I think the lady was older, and she was going into a home or something like that, and he readily admitted, he said, I haven't been there in 15 years, but I never had to be. Well, when she moved out, he realized he should have been there a heck of a lot more. I wouldn't say damage, but wear and tear off the radar. Okay, so, spilt stuff that was never managed, or a mess here and there that just has now created a damage to this, and just stuff he found where if he had just gone there, he could have addressed it. So I remember that story, and I always try to keep that in my mind too. But,
well, and there are maintenance standards as well.
Sure.
So, a story to go off of, I just assume that my tenants are going to tell me when things are happening. I unfortunately had a landlord, elderly lady, who owned multiple houses, and said, if the tenants have an issue, they'll come and address it with me. She was like, I'm just giving them their privacy. I can understand her side of it. But 5 years she hadn't been in this home. A front porch railing fell off. Tenant got upset. Filed a tenant application, rent abatement, that kind of thing, because maintenance things weren't being addressed. And he got it. So out of no particular fault, other than you not maintaining or at least understanding what does your property look like each year, you could get orders against you for the tenant to have a reduced rent or a rent abatement because they've had to live with certain circumstances.
Wow.
So.
But that is your it's your responsibility, though. So when you put it the way you had put it, there is that responsibility. And again, I think most 9.99 times out of 10, most landlords are pretty good about stuff. Something breaks, you fix it, or whatever the case may be. But when you hear stuff like that, it's like, well, that's a good point, right?
I think they're all good at fixing things.
Sure.
And they're all good at maintaining their property.
Yeah.
If they knew about it.
Yeah. Yeah, that's very true.
What you're not going to get are these other stories where Tenants won't ask you to come and fix anything because they've decided one of the rooms needs to be a stable in their home or other things. I think when I first started practicing, there was an indoor garden in the living room of an apartment. So sometimes these are cultural situations
fair enough,
that new immigrants, maybe that's how they lived in their home country and don't understand what you can and can't do in a building in Canada. So, I mean, there are tons of stories, tons of what we would think are outrageous, crazy, different,
Of course.
unbelievable. But think of how they come to be.
Yeah.
They don't necessarily know that this is wrong or they can't do that.
Yeah.
Some do,
Yeah.
but
Yeah, exactly.
I mean, it takes all, right?
Yeah, that's right. Yeah. Anything else on mistakes new landlords make?
I think
those
are the
pretty
big ones.
Yeah. And those are the ones we hear about, right? Those are the ones we hear about. So.
Yeah. And I think probably one other one would be, don't fall into the trap of a tenant requires a place immediately. Okay. Certain red flags when I do teach to new landlords is there are some red flags out there. One is the credit check. Make sure you call everybody. We talked about that earlier on. The next one would be nobody needs a place tomorrow. You know, someone moving in from a different city because they got a new job.
Yeah.
Pretty much sure they would have had advance notice of some kind before they come in. Typically, I find the ones who need it immediately are usually ones you probably want to watch.
Gut feel.
Sometimes.
Yeah.
And again, it's not always the case. There are always circumstances where something does happen that requires someone to need a place immediately. So know your gut. Just
ask questions.
If that seems a little bit odd, then it's not to say not to rent to somebody. Just know if that seems a little bit odd, then maybe you want to just dig a little bit further as to the reasons why that's occurring.
Yeah.
Just to secure yourself, because again, it's a lot of money that you could be out potentially in not a great decision. And unfortunately, the landlord and tenant board does take a while for things to get through.
Yeah, to do the right thing up front, right?
That's just, today's times at this point. And we can deal with things. It's just all going to take time.
Yeah.
And address complaints.
From the tenant.
Any tenant.
Yeah.
Yeah. Yeah. You have to address any complaints that come by.
And get it in writing from them, I'm assuming. Respond to them in writing. Make sure all that communication is happening and it can be documented.
Yeah. This could all be a whole other podcast, I'm sure, based on complaints. But to keep it really brief for this part of it, understand that you cannot be biased. You have to take the complaint and you need to address that complaint in some fashion. You are not the adjudicator. You are not the one who decides who's right or wrong in a scenario. You just have to ensure that you're addressing it.
Sure.
Because it can come back on the landlord if it is not addressed.
Yeah. Really quick text messages, good, bad?
They can be okay.
Okay.
If the tenant and the
that's
landlord...
That's a really gray answer area. Gray area answer. It can be
great. Depends on how... If you always communicate via text message, then a lot of the times we do use as evidence a lot of text messaging.
Okay, so law's starting to catch up a little bit then.
It can, it can work. There are various things you can't use text messages for. So notice is to enter unless they agree or consent, which is where the standardized
consent
lease
to communicate that way.
Yeah.
And that's okay. Okay, that makes sense. And that putting two and two together, okay, that makes sense.
And the standardized lease agreement has that.
Oh, okay,
If they're long-standing tenants and you have a different lease agreement with them, there is a form online that they can sign,
Interesting. Okay.
consenting to that way of communication.
Yeah.
But understand that that communication is strictly for the purposes of communicating. It is not for serving notices ever.
And we serve notices by what? Forms on doors, or how do we go from A to B?
Right. Never, ever post a notice on a door.
Okay. That's old school, right?
Right.
We used to do that. Okay.
You can, what is still allowed is notice to enter can be posted on a door, but no other notice. I personally don't like any of them. To me, that's a privacy
well, that would make sense. That's the reason for it, right?
Yes.
Okay.
But even posting a notice to enter, to me, just it's in my view still a privacy issue.
Yeah.
The Act allows that to occur. So notices to enter can be text or emailed, provided they have consented to that. Always get some kind of acknowledgement from your tenant with that. Any other notice has to be done by the way what's board prescribed. So the certificate of service would explain that. Really, you can hand it to them.
Okay.
You can place it in the mailbox where mail's normally delivered.
So you're still leaving it at the house, but you've got it like mailbox or something like that, right?
That's right.
Oh, okay, that makes. I can just like a stakeout, right? You're sitting outside the house. When are they coming home?
No, so mailboxes are great because you just need to place it in there.
Okay.
But then again, if you've got a place with a community mailbox, then you're going to have no choice but to mail it by Canada Post.
So does it go by post date of like the second of the month? Is that when the clock starts?
Well, if you're mailing it, you need to add 5 days to your termination date.
Oh my God.
So there's all these little nuances that occur.
So I understand what you said earlier, but it's their place to live in the whole bit. But I'm thinking, oh man, okay, I'll just wait out front to see them. Like, here's your notice.
Yeah, or slide it
Not
on
the right thing.
Yeah, or slide it under the door.
Okay, that's okay too. Okay, fair enough then. All right, that's good.
Yeah. So the forms tell you.
I can just imagine the mail. 5 days, no way.
Yeah. You know, the forms will tell you how to serve. The board website will tell you how you can serve. Even though there are check boxes that say you served it in a different method, you can't just decide you're going to email it and check off that box. It is not prescribed. It has to be order of the court.
Email, I can just imagine. Well, I didn't get the email. Went to my junk mail. I can just imagine that.
Yeah.
Right. So. Okay, Lisa, this has been fantastic having you. We're going to have you back because I can just see it. This could be an 8-hour podcast. So we have to have you back. Thank you so much for coming. And like I said, I really want to capture, what you do in your role and how you help people and best practices and stuff like that. And I can just imagine people are probably going to be listening, just jotting things down because it's so easy to mess up, but it's also what my teachers used to tell me in elementary school. It's so easy just to get it right the first time, right? So we'll have to have you back, but thank you so much. Now, if someone, again, we're all about shameless plugs here. So if someone wants to reach out to you, questions, how do they get a hold of you? Name, number, email, how do they get a hold of you?
Yep. So probably the easiest way would be on my website. So smallmatterspa.ca.
Okay.
And from there you can access my email. Phone number is 519-648-9675. I have no problem answering a few questions. If you have a quick question via email, I do speak to lots of people. It doesn't mean that you have to come in for a meeting all the time. Sometimes it's just a quick question. I'm going to explain it to you. The other option for anyone out there is just call the landlord and tenant board too. If it's a quick question and you can't get it answered or you're not sure, call their number, reach out on their website. There's a ton of information.
Yeah. I think in fairness to you too, I mean, if it is a question like that, they probably are your best first contact, right?
I'm good either way.
Okay, cool.
So if I'm available,
I just don't want
answer.
your phone to be lighting up after this. Trying to help you here, Lisa.
That's okay.
Very good. Okay, well, again, thank you very much. And folks, thanks for listening. And until next time, we'll talk to you soon. And there you go. There is Lisa Nadon with Small Matters. Hey, make sure if you've got any questions, reach out to her. She is awesome. Thanks for listening, everybody. Don't forget to follow me on Facebook and Twitter. Same handle, RBC Stephen Green. Until next time, we'll talk to you soon.
Thank you for listening to the Green Effect Podcast. Subscribe to this podcast on iTunes or Google Play so you catch the next episode. And don't forget to leave a review. Much appreciated.